So I think the question now is where to from here? Where do we go? What's the effect of this decision on average adjustments moving forward? Is it limited to its own facts, or does it have more wide-ranging ramifications? So it's important to note that the Longchamp was decided on 1974 York-Antwerp rules, and there have been 3 versions since, with variances as to whether the versions are more cargo-friendly or more ship-owner-friendly. For example, the 1994 rules are the most prevalent in the industry, except for some oil majors and the US government, which readily adopted the 2004 rules, which are seen as more cargo-friendly. But also remember that the rules only have legal effect through contractual incorporation into contracts, into the carriage contracts. And importantly, there was a rule Paramount introduced in 1994. And this rule Paramount, it arguably introduces an overriding reasonableness element to all allowances. However, in the Rule F context, it seems an open question in light of this decision as to whether this reasonableness element applies to either 1, the GA expense avoided, as cargo unsuccessfully argued in the Longchamp; 2, that test applies to the substitute expense itself; 3, that it applies to both, that is to the GA expense avoided and the substitute expense. And incidentally, this was the view of UNCTAD, the Secretariat in March 1995, when it looked at the new rule Paramount, and it said that it applied a test of reasonableness to both the course of action taken and that for which it supposedly substituted. Or 4th, lastly, does it have no real effect? Because the clause Paramount can be viewed narrowly with respect to Rule F expenses, just as Rule A, reasonably incurred, was viewed narrowly. And I noticed that it was Michael Harvey of Harvey Ashby Adjusters, a fellow of the AAA, the Average Adjusters Association, and he held that view. And remember, it can lead to reasonably this reasonable test can lead to very odd results. My own view, and it is only a view, I think each case can be argued differently, and as we saw here, there's varying views on this. But the law, I think that there's an argument to say it supports the 4th option. I think Mr. Harvey has a point, because it seems to me that the rule Paramount can be read as applying to only allowances for sacrifice and expenditure, rather than additional expenses incurred to avoid sacrifice and expenditure. I also think that there's an argument about reasonably incurred, and that for substitute expenses this only refers to nature and not quantum. And overall, I think that the rule Paramount, it will not cut out these negotiation expenses, and indeed such negotiation operating expenses could be claimable when negotiating a GA repair bill or salvage costs for that matter, and they're not only in the piracy GA cases. However, I suspect there may be pushback in the average adjusting community, and indeed I'll come on to a commentary which the AAA have given. And I think there are going to be attempts to distinguish the Longchamp in adjustments on new versions of the rules, and or to apply a reasonableness standard to adjustments allowing negotiation expenses, especially because the deliberations for the inclusion of the rule Paramount at the Sydney CMI conference in 1994, it seemed to accept this reasonableness threshold would apply to Rule F, like all other allowances in the York-Antwerp rules. For those reasons, if a reasonableness test applies, it is likely to be I think, whether it was reasonable to incur the substitute expenses instead of the GA expense avoided. Time will tell, but we might find some herald of that approach, this approach of the average adjusting profession in a 25 January 2018 paper in their advisory committee report put out by the Association of Average Adjusters, the AAA. And the AAA, they analysed each part of the Supreme Court's ruling, adding additional commentary, and when they came to summarise and conclude on their views, it referred to possibly far wider applicability than the saving of large sums in the emotive arena of crew held hostage at gunpoint. Certainly the notion of reasonableness heads the AAA list. And though the report rightly cautions that we must await application of the decision to other facts, it's not hard to see this precise issue coming back in, especially among practitioners who will intuitively and routinely consider it. So it is very likely that reasonableness will somehow be considered when assessing maybe a wide variety of more routine time-based costs, which is said to have achieved a saving. However, I hope and believe that the AAA would not dispute that, albeit maybe with some odd reasoning, in the result, this rare Supreme Court decision on GA will allow sharing of proportionate costs in yielding perhaps significant saving. It is hard to argue with that, to be honest. In this case, when you think that over $4 million was saved for only $160,000 in OPEX costs, it seems hard to think this would not meet any reasonableness test. So that concludes my presentation. I hope you've enjoyed it. It's been a discrete area of general average, but really allows us to get back into the matter and assess a key area. If you'd like to discuss any issues arising, feel free to contact myself or my partner Ed. Happy to speak about GA. As I've said, we've had a few issues dealing with GA recently, and it's something that falls within our practice, and happy to speak about it informally or of course more formally. If you have enjoyed this presentation, if you've liked it, feel free to share it amongst your network and send us any feedback. You can also follow us on Twitter and on LinkedIn, and we're looking to build up our list there. So more of this content will be circulated. Thanks again for your attention. Bye.